Welcome to our monthly discussion of recent topics and decisions in the area of patent law, with a particular emphasis on patent prosecution. I'm Joe Murphy.
I'm Reza Mollaaghababa.
I am Reza Sadr.
And today we have a really interesting topic in the area of artificial intelligence. So we're discussing some recent USPTO, United States Patent and Trademark Office guidelines on whether or not AI can serve as an inventor on a patent application. And then we'll also be going through some recent guidance that has been promulgated by the USPTO with examples in claims that recite artificial intelligence. So, Reza, I think you're going to start. I'll bring up the slides.
Yes, thank you, Joe. Hello, everyone. So as we all know, AI has become an important aspect of our lives, and it's being used in a variety of industries. So as a result, also, there has been new thoughts and discussions and guidelines regarding the use of AI in generating patentable subject matter. And more generally, with regard to the use of AI and intellectual property, including copyright. So there has been developments in these areas. And today we're going to concentrate on patents and the recent guidelines that have been published by the USPTO with regard to whether or not the use of AI would preclude obtaining a patent, and also other issues regarding patent eligibility. So one of the requirements in the US for obtaining a patent is that a natural person be identified, one or more natural persons be identified as inventors. And when you're using AI, of course, AI is not a natural person. So the question arises whether the use of AI would preclude obtaining a patent for a new invention. So the USPTO guidelines indicate that that's not necessarily the case. As you see in this slide, AI-assisted inventions are not categorically unpatentable due to improper inventorship. And here's the important part: if one or more natural persons significantly contributed to the invention. So if the AI is used, but in addition, there has been significant contribution from natural persons, then at least with regard to the inventorship issue, one overcome that hurdle. And then, of course, one needs to worry about the other patentability requirements. So USPTO guidelines provide some examples, and here's one of them. And in this example, basically, a professor and her postdoc, they were interested in obtaining or identifying compounds that would provide good binding with a mutated receptor, androgen receptor protein. And they used AI, and they provided the sequence of the amino acid sequence of the protein to the AI system, and also a number of different potential compounds. And the AI basically provided them with a binding efficiency of those compounds to the receptor. So there was a score given to each compound in terms of how tightly they would bind to the receptor. The professor's postdoc looks at the list of these compounds and the binding efficiencies, and realizes that the most promising compound that had the strongest binding to the receptor would also bind strongly to the natural or wild type receptor. So that meant that it could potentially have side effects. So the professor and the postdoc then try to come up with an intermediate compound and modify that intermediate compound to arrive at a compound that was a modified version of the compound that the AI had identified as the most promising one. And that modified version, they believe that could be particularly efficacious for treating prostate cancer. They file a patent application, and the patent application has two claims. One is a method of identifying and synthesizing a lead drug compound for treating prostate cancer. And as you see within the claim, they identify that they used AI. And then there was another claim, which is the next slide, that basically claims the modified compound itself. So in this example, the USPTO guidelines indicate that in this hypothetical example, that the postdoc and the professor and the postdocs have contributed significantly beyond what AI had done. AI had provided a score in terms of the binding efficiency of the compounds, but they had contributed both in terms of realizing that the lead compound may not be necessarily particularly suitable because of potential side effects, and they had contributed to obtaining a modified type of compound. So both claims were deemed as being eligible in the sense that there is no inventorship issue here. Natural persons had contributed significantly to the to arriving at these two claims, at the subject matter of these two claims. And then, of course, there are other situations that may not be the case. I mean, as we're going to discuss later, in many cases, the situation may be a little bit less clear, and there could be difficulty in determining whether, there is really enough contribution from a natural person. But I guess those cases will have to be dealt with on their own merits as they come. So at this point, I think I turn it over to Reza.
Reza, I have a question for you actually regarding this. You alluded to it. Does the guideline provide any help or details of what significantly more means here? How much is significantly more?
That is, no, well, I mean, they try to provide examples as way of describing what significantly more means, but as you can imagine, that could be a point of contention in a way, depending on what the situation was. In this case, they did modify the compound, but let's assume the hypothetical was different, and rather than modifying the compound, they realized that the lead compound had difficulties with regard to side effects, and then they would go for, pick the second compound. Would that situation be a case in which they would be considered as inventors? One could argue on both sides in that situation, right? It's a little bit more complex than this case. So they try to provide examples, but as we all know, this is what lawyers argue about, what significantly more means. And it depends on the particular facts of a case.
So
Reza, maybe I'll jump in and ask a question here. Given the requirements of duty of candor and duty of disclosure for us as patent practitioners, and also, of course, for the inventors themselves, is there do you think there would be some requirement that if AI was used in the as part of the inventive process, does that need to be disclosed to the USPTO, do you think?
That's an interesting question. As far as I know, at this point, USPTO does not require that inventors indicate that, for example, in their declaration that AI was used, although in cases like this where there is AI explicitly disclosed in the application and also in the claims, it's clear that there is some, there has been use of AI, but at this point, I don't believe that's the case, that one needs to disclose that. But although my understanding is that Copyright Office requires that. But going forward, I mean, that could clearly change as AI is used more frequently.
It's an interesting point you've raised about the Copyright Office, because, I mean, they've had issues where owners of copyrights have applied and said that AI was the author, and of course the Copyright Office says that it has to be a human person that gets the copyright, it can't be an AI that generates it and will get a copyright. So it seems like the US federal government at least has stepped in and said, okay, well, at least for patents, you need a human person as the inventor. For copyrights, you need a human person as the author, at least at this point. Even though an AI can contribute to authorship or inventorship.
Right.
I think this is a very interesting point and discussion, and I want to reemphasize that in light of these examples, actually, that you just mentioned, the claim 1 and 2. The fact that AI is involved in an invention could come up in two different ways, at least, in my opinion. One is that, as Reza explained, AI itself was involved maybe in the conception or in reduction to practice. And maybe that doesn't jump out from the claim itself. I guess even it may not be even mentioned in the application at all. And that's the question of inventorship comes up. So when we look at this claim too, assume this was the only claim, nothing shows here that there was AI involved, but I guess for USPTO, then it's important for the disclosure that you mentioned, and I wonder whether they have to start adding even statements or questions in the declaration to require the inventor to mention explicitly whether AI was involved. Claim 1, if we can quickly go back, still we have the same invention. We have AI involved, in this case, in the form of deep neural network. But here, even the claim tells us there's an AI involved. And that's when not only the inventorship comes up that Reza explained, but also whether the claim itself, if subject matter eligible, because it includes AI, which I guess is the next thing that Reza is going to explain further in regards to the guidelines.
Perfect. Well, okay, Reza, here. Do you want to
Yeah,
give
so
some background?
I'm gonna try to do this quickly because you guys are gonna talk in more detail with regard to specific examples. But AI, when it comes to the question of patent eligibility, in some ways, the guidelines are similar or almost exactly the same in some sense as those that are utilized to determine whether computer implemented inventions are patent eligible. And this is a flowchart that USPTO has provided to help sort of navigate this issue, the so-called 101 issue. So whenever you have a claim, the first step is to determine whether the claim relates to a statutory category of inventions. Is it a method? Is it a machine? And typically there's no issue there, but the issue comes in the second question. And the second question, step 2A, is whether a law of nature or an abstract idea is involved in the claim. And then if yes, then the inquiry still is not finished. One has to determine whether there is the claim relates to a practical application of the abstract idea, or the claim, which is the step B, provides additional elements that amount to significantly more than the abstract idea or the law of nature. And that analysis now we have been using in various inventions, including diagnostic, some pharmaceutical inventions, and clearly computer-related inventions for a while. And so in some sense, the analysis of claims that involve AI follows the same path as Reza and Joe are going to describe with respect to some examples that the USPTO has provided.
Okay, I want to reemphasize what you just said, so I won't go through it much, but guideline specifically mentions and agrees with many of the stakeholders when they provided comments that AI is nothing, in that sense, nothing new. It's just a computer-enabled invention, essentially almost always a software-based invention. So as a result, in this guideline, there was nothing that was added specifically for AI. All the USPTO did is apply the existing guidelines, which are summarized in those flowcharts, to the case of AI inventions. But it's a good thing because, as mentioned, AI is now becoming so widespread that it should come up a lot in the inventions. So what USPTO did in an addendum to the guideline is provide 3 examples. And they were numbered 47 to 49 because they follow the previous examples provided by the USPTO in relation to the previous versions and incarnations of the guidelines. And these 3 we're going to go through. I'm going to mention 2 of them, 47, 48, and Joe is going to explain 49. In each case, before the claim comes a section called the background, which plays the role of like detailed description and provides the support for the terms or an explanation for the terms of the claim. I won't go through that because more or less the claim itself explains that again. So example 47 had to do with anomaly detection, and it has 3 claims under it. The first claim, as we see from preamble, is directed to an application-specific integrated circuit, so-called ASIC, for an artificial network, which is abbreviated to ANN. And then it explains the elements of the ASIC. And as you see, 2 general subparagraphs here have elements listed as neurons, which have the plurality of neurons, each having a register, a microprocessor, and at least 1 input. And the second part, the plurality of synapses circuits, those are the connections between the neurons, including a memory for storing the weights, and also this essentially says that the synapses connect neurons, which is very familiar picture for neural networks. And here the analysis, when we go through the flowchart on the right, the point is that there's nothing in this claim that can be identified as an abstract idea, law of nature, or natural phenomenon, which come under the general term of judicial exceptions, which started this whole story many decades ago. As a result, right at this first step, in prong 1 of step 2A, the answer is no, there's no judicial exception here. There's no recitation of such. As a result, it's already eligible, and we won't even go through the details. I want to mention that this type of claim is usually never at issue, or very rarely. I mean, it's obvious. Although we may always get rejections, there's nothing beyond an examiner to even reject this. But the answer is just that. There's no element here. Can we go to the next claim, please? Under the same category, now we are having claim 2, which is a method. Now here we go into some details of how this anomaly detection works. I want to mention what I didn't mention in claim 1, but Reza mentioned in the whole process, that all these claims first go through step 1, which we haven't brought here because almost never it's an issue. The question is, does it fall under the categories of patentable subject matter in general, the 2 categories of process or product, which itself could be different types. And here we are dealing with a process. Step 1 have not come here because the answer is always yes. We get into step 2, and now we have step 2A. Let's look at the claim. It's a method using neural networks, and it has these steps: receiving training data, discretizing the data. And the data here, as the background says, essentially are related to signals that may be exchanged in a network, in a computer network. And the idea of anomaly detection is detect signals that in principle could be malicious, could be malware, detecting them and possibly doing something with them, like blocking them. So in the discretizing part, those signals are used to train the neural network through a process very well known as supervised learning for a neural network. Next step is the training, using a training algorithm, using the input data. And the training algorithm includes a backpropagation algorithm and a gradient descent algorithm. Again, very well known in the technology of neural networks as part of the training. And then detecting anomalies in the data set. So here we have trained the neural network. Now we apply it to the another set of data to detect the anomaly, and eventually step E here, analyzing those detected anomalies using, again, the neural network to generate anomaly data, essentially point where the anomalies are, and then step F, outputting them. Now here the analysis says, let's go back to prong 1. Are there any judicial exceptions recited? The answer is yes. Essentially, I have colored them in red just to point them out. Actions such as receiving, discretizing, and detecting, all these could be in general interpreted as mental processes. And then we have parts that include backpropagation algorithms and gradient descent algorithms. In principle, these are mathematical processes or mathematical formulas. They all fall under the general category of abstract ideas. So the answer is yes. Now that we have passed prong 1 in this way, we have to go to prong 2, and the question is does the claim recite any additional elements that integrate the judicial exception into a practical application? The answer is no, without going into details, because in the next example, we see when the answer could be yes. But here, there's no extra element, and that is true also for this whole thing finishes the step 2A part, which now has 2 prongs added a couple of years ago by USPTO. We move on to step 2B. In that step, now the question is, are there any additional elements that are significantly more than just what we have seen, the judicial exceptions? The guideline itself mentions, and even in the examples, that there's a lot of overlap between step 2A and step 2B analysis, especially because they both talk about additional elements. But the way of analyzing them is a little bit different. And I'm going to get to when the answer to one of them is yes. So if we move on to the next claim, please, under the same invention, and here I must have mentioned earlier that USPTO says these are not real inventions or near application. They were made up by USPTO based on existing technology and known technology in the literature. Here we are again dealing with the same method, and assume the same method of claim 2, only we have additional elements here, the steps E and F in this case. And here we are talking about dropping those malicious network packets that were identified by the neural network and blocking future traffic from the source that sent them. These are very practical uses of what we already saw in claim 2. This is the way to protect a network or a system. And that's why now, when we go to prong 2, now we have, what does it say? We have integration of the judicial exception into a practical application. Here, what I just mentioned, the protection of a system. And in this prong also sometimes is formulated as a technological solution to a technological problem. Same thing. It passes that gate. In other words, the answer is yes. So overall, the answer is this is eligible. Claim 3 is subject matter eligible. Now, if we move on to claim example 48, please. Now we are dealing with different invention and different technology, again, made up by USPTO, about a speech separator, essentially receiving speech signals, voice signals, translated and converted into electronic signals, and then analyzing them and possibly identifying different speakers in the signal and then doing something with that. For example, focusing on one of the speakers or excluding one of the noises or speakers from the whole signal and outputting them. So claim 1, again, is a method, includes the receiving the signal, which has to do with the speech or the general sounds, and from different sources. The source is important here. That means maybe the speakers. Then converting the signal into a spectrogram, essentially some conversions well known in the technology, and using Fourier transform and obtaining feature representation. So essentially transforming the signals into something which is mathematically defined and can be quantified and compared. And eventually, using the deep neural network, here is how we have the use of AI to determine the embedding vectors using some formulas. So essentially identifying the different sources. And so that's the end of the claim 1. This is ineligible. When we go through the elements, very similar to what we mentioned in the previous example, we have judicial exceptions here, which could be mental processes or mathematical formulas such as Fourier transformation or the formula colored in red in part C. And then when we go prong 2, again, the answer is no, which we can contrast with the next claim where the answer would not be no, or maybe in the next step. But here we don't have anything in the judgment of guidelines here that applies this to a real problem, a technological problem. So the answer is no, and then it has to go to step 2B, which is now, is there anything that does significantly more in the claim? And the answer is, again, no, nothing is identified. This claim is deemed ineligible. If we can go to the next claim, please, under the same technology now, again, assume we have the same claim as claim 1, but we have added some additional steps, which is when we have different sources, that's the part which is now colored in green, excluding the speech waveform from a specific one of the sources, which is called here target source, and then transmitting that mixed speech where the target source has been removed to a remote location. Here, again, prong 2 now goes in a different direction. Instead of no, we say yes, which means there is an application of those judicial exceptions, in this case, abstract ideas, into a real practical industry, a practical use, or in other words, there is a technological solution, which is use of AI and all the other things, to a technological problem of identifying different sources and even separating them, which can have many uses. So this was, I think, the end of example 48, if I'm right. And I know, oh, there's a claim 3, I apologize. I take that back. There is another example here, I forgot that. It's essentially the same as claim 2, I would say, maybe with a different wording, but in here, we are now dealing with different category of subject matter eligible, of subject matters of invention, which is now a non-transitory computer readable storage medium, a phrase very familiar to practitioners, essentially talking about maybe a software which is saved or a program which is saved in a non-transitory medium. And here, assume same claim process plus the same similar steps, which is producing a transcript of a speech signal corresponding to the target source. Here, we have done the opposite. Instead of excluding the target, we have especially extracted it, focused on it, which is a very practical use, as we know, could have many uses in speech recognition and transcribing conversations. And here, again, we pass in prong 2 in a similar way, because this is a practical application, and thus this claim is eligible. Thank you. We can move on to claim 49, and to you, Joe.
Thanks so much, Reza. That's really great. So this is the backstory on this one is it's a treatment for glaucoma, basically. Of course, glaucoma is high intraocular pressure in the eyes that can actually lead to damage of the optic nerve. And so you try to keep the pressure low. Now, there's a couple different ways you can treat glaucoma, of course. There's eye drops, things like that. There's also surgical methods where a surgeon can drop a stent into the eye, which is essentially a pressure relief valve, and it'll keep the intraocular pressure at a certain level to avoid damage to the optic nerve. One of the problems, of course, with surgery and putting a stent in someone's eye is that it can lead to inflammation, and it also can lead to the formation of fibrosis. It can get fibrotic. So the method here is post-surgical treatment method, and the theory here is that we'll be collecting and genotyping a sample from the glaucoma patient and identifying the patient as being of high risk of what so-called post-inflammation, implantation inflammation, which they call PI, based on the presence or absence of what's referred to as SNPs, right? Single nucleotide polymorphism. So these are known indicators of certain alleles that will lead to a certain phenotype that will increase the risk of that particular patient for having post-implantation inflammation. So it's essentially a method of personalized medicine. So as part of the method, we see here, step A is collecting and genotyping the samples. Step B is identifying the patient based on their weighted polygenic risk scores. So that's generated from these collection of SNPs, and they run it through their easy AI model, so-called, and that uses multiplication to weight the corresponding SNPs or alleles in the data set based on the expected effect on whether the patient or not would have a higher risk for post-implantation inflammation. And then, so let's go through that first. So here we look at prong 1 of step 2. Does the claim recite an abstract idea, law of nature, natural phenomenon? Here we've got several actually that are mentioned, and actually it's probably all of them, right? So as an abstract idea is something that be done purely as a mental process. Here we've got a physician can identify the patient and could look at these SNPs and determine it in their mind as to whether or not the patient has a higher risk. So it's not necessary to use an easy AI model. We have a law of nature and the fact that we have a correspondence between what the patient's genotype is based on these SNPs that they collected and whether or not they're going to be a higher risk for inflammation. So that's a law of nature or natural phenomenon. And so we've kind of got all, and we've also got mathematical issues here as well, right? Because the easy AI model is going to be a mathematical computer program. It uses multiplication, uses addition. So again, we've got mathematical concepts. So it goes yes, and it goes to prong 2, which is does the claim integrate those exceptions into a practical application. So let's jump down to step C here, administering an appropriate treatment to the glaucoma patient at high risk of the inflammation after microstent implant surgery. Now, that's going to be considered, the answer to that is going to be considered no, because it's not a practical application, because it sort of blocks out physicians from doing it covers any kind of treatment. It doesn't cover one treatment in particular, so it's not really, it doesn't reify it. It's not a concrete example. It's not a concrete practical application, I would say. So we go down to 2A, and then we go to 2B, which is there significantly more than a judicial exception? And again, here, the answer would come out as no. Now, I think at some point, we plan to do one of these videos in more of a deep dive into this 35 USC 101 patentable subject matter issue. And so this claim reminds me a lot of the Mayo the Prometheus case, which we'll get into. But I think that claim, the claims at issue in that case, which is a Supreme Court case, kind of similar to this one, except they added the AI model concept to this, and so came out in a similar way. The claims are ineligible. So let's jump to the claim 2. Okay, now we see a lot more green on the slide, so we can figure out this claim is going to come out as being patent eligible subject matter, right? So here we've got, it's all the steps of claim 1 are incorporated into this claim 2, with the additional step of wherein the appropriate treatment is compound X eye drops. So now we've got an administration step. So now instead of taking all the other steps that were kind of mental processes and abstract and mathematical concepts and things like that, laws of nature, correspondences. Now we've got the specific step of using a specific compound in the eye drop, administering that to the patient. So here we're going to go into, we're in step 2A. It recites the abstract ideas, et cetera, as from claim 1. But now we've got, in our prong 2, we've got additional elements that integrate this into a practical application. So therefore, the claim is not directed to a judicial exception, and therefore it's considered patent eligible subject matter. Again, a little foreshadowing when we do our deeper dive. This is similar to a CAFC case actually called Vanda, and I'm sure we'll go through the compare and contrast Mayo versus Vanda, and it will come out in a similar way. So I think that's why we end up this as being considered patent eligible subject matter. So.
No, that was really interesting. The 101 analysis, it has its own vagaries, I guess. And in this case, one could potentially argue that administering treatment could be viewed as a practical application, and maybe a better way of looking at that claim would have been to consider whether the applicant had provided enough written description support for such a broad statement as using any type of treatment. And one could have argued that the scope of the claim is not commensurate with the scope of applicant's disclosure.
You are talking about claim 1, right?
Claim 1, right. You're talking about claim 1.
So you're talking about step C.
Step C. And that is where I think sometimes, from my point of view, it would have been better if the case law had gone towards the direction where the 101 eligibility was a lower bar, and some of these issues could have been dealt with using other provisions of patent law. But maybe those are some of the things we're going to touch on when we talk about 101 in more detail.
Yeah, I think to me, the issues about the 101 analysis, especially in the step 2B, significantly more. And I know this is controversial, I guess, but that overlaps significantly with obviousness with 103. You know, you're looking at the state of the art and determining if it's considered significantly more than what the state of the art is or not. I mean, I think in the Mayo, as I'd mentioned, this claim 1 of example 49 is similar to the Mayo case, and I think in the decision from the Supreme Court, they were concerned about blocking out physicians from doing any kind of treatment intervention. The claim was so broad, you know, like this one, it says any appropriate treatment. Well, that's anything. But I think you're right, Reza. I mean, I think that could have been dealt with under, you know, 112, under a written description, as you say. It could have been dealt with under enablement as well. Did they enable any possible treatment intervention to treat this glaucoma? Well, no, they didn't. They were probably enabled and described this one particular intervention, I would think. So yeah, I think that's something we can get into, whether or not 101 really is the best way to analyze these things. But this is what we deal with when we write these applications and prosecute these applications. These are the types of rejections that we can face and try to overcome.
This is very important. It has been pointed out several times by critics of these new guidelines that this patent office essentially, or the whole law, starting from Supreme Court, have brought many of the analyses which have already been developed and well established and very well organized, like 103, 102, all of those now have a procedure behind them historically. If you remember, before 103 came the way it is now, we had this concept of inventive element that the Supreme Court and the law tried to move away from, and now it has snuck back sometimes under exactly this analysis we have in front of us, the so-called inventive step. And they always say, maybe that's not the right thing. Historically, something happened that the patent office and the law brought it under the discretion of the examiner, just using 101 with less rigor. Anyways, I have a question for you for claim 1. What do you think, Joe, if you go to claim 1, how relevant is this use of and then a use of AI for bio areas in this form that we have in this example? Is it a good example?
I think it's a good example in the concept of personalized medicine, which I think is something that's becoming more and more, it shows up more and more in the literature, where, you know, the interventions are going to be based on patient's exact genotype. Here we're looking at their genotype based on these certain single nucleotide polymorphisms, and customizing the intervention, the medication, or whether you're going to do a surgical intervention, something like that, are personalized to the patient. So I think AI in this context, this is a good example. And I think actually the claim 2 that Reza had discussed about with the in the inventorship that we discussed earlier, where PI and the postdoc took some AI generated compounds, you know, looked at them, did some substitutions, things like that, found a better compound. You know, that's typically the way. Typically, that would have been done, instead of using AI, it would have been done using a compound library of thousands and thousands of compounds that you know, the PI and the postdoc would have gone through and said, okay, these 100 or these 1,000 look good, so let's do substitutions on these and try to find out which ones are best. And that's a typical way to do NCE, new chemical entity type drug discovery. Now we've just replaced that with AI in a sense. I think these examples are good because they show the way AI is being incorporated into inventions now. So I think they're good. I think they're good examples. Yeah.
Perfect. Thank you.
All right. Should we wrap it up there? That sounds great. It's really good talk. Hope everybody enjoyed it. Any questions? Oh, here's our contact information if you'd like a copy of the slides. please feel free to reach out and send us an email. And with that, I think we'll say, everybody have a nice day.
Yeah, thank you, Joe. Thank you, Reza.
Thanks.
Bye.
Bye-bye.
Bye-bye.